Hello, good afternoon, everyone. Welcome to part 4 of the lecture series on criminal procedure. This afternoon, we are going to discuss about prosecution of civil actions under Rule 111. Last time, we were able to finish discussing Rule 110, which is institution of criminal action. So under Rule 111, we're going to talk about how a civil action is prosecuted in court. So let me share my screen. Okay, prosecution of civil actions, Rule 111. Now, class, we have discussed last meeting that in each criminal complaint that is filed in court, a civil action arising from the delict is impliedly or is deemed impliedly instituted with the criminal case. So again, whenever you institute a criminal action, that criminal action will come with it or will bear with it the civil action arising from the delict or crime. Now, as a general rule, the institution or filing of the criminal action includes the institution therein of the civil action for the recovery of civil liability arising from the offense charge. So this is the general rule. However, there are exceptions. When the offended party waives the civil action. Number two, when the offended party reserves his right to file a separate civil action. Or number three, when the offended party institutes a civil action prior to the criminal action. So class, I have a code for these exceptions. Under the exceptions, whenever a criminal action is filed in court, the civil action is not deemed impliedly instituted from the criminal action. No? Ibig sabihin, pag nag-file ka ng criminal case, hindi kasama yung civil action under the exceptions. And what are the exceptions? My code here is WRP. Now, WRP. Now, when the offended party waives the civil action, definitely the civil action is no longer part of the criminal action because the private offended party had already waived or renounced the civil action or damages arising from civil liability from the offense charge. So, ibig sabihin, the private offended party is no longer interested to seek damages, which is why even if he files a criminal action, that criminal action will not include the civil action for the recovery of civil liability arising from the offense charge. Okay. The second exception is when the offended party reserves his right to file a civil action. Now, under the second exception, when the private offended party intends to file a separate civil action, then definitely the criminal complaint would not comprise the civil action arising from the offense charge. And the third exception class is when the offended party institutes a civil action prior to the criminal action. Okay? So WRP waiver, reservation, and prior institution of a civil action to the criminal action. Okay. Okay. Now let us go to the first exception, reservation to file a separate civil action. Okay. Now, jurisprudence instructs that the reservation may not be necessarily expressed, but it can be implied, which may be inferred not only from the acts of the offended party, but also from the acts other than those of the latter. So, this is the second exception by which the institution of the criminal action will not necessarily include the civil action when there is reservation. When you say reservation, the private offended party is impliedly or expressly reserving or setting aside the filing of the criminal action in the meantime. Now take note that the failure of the court to pronounce judgment as to the civil liability amounts to the reservation of the right to file a separate civil action. Now, the question is, when can the private offended party reserve the right to file a criminal action? The reservation of the right to institute separately the civil action shall be made before the prosecution starts presenting the evidence, and under circumstances affording the offended party a reasonable opportunity to make the reservation. So under the rules of court class, the reservation to make the right to make reservation, rather, to file a civil action arising from the delict or the crime can be made before the prosecution starts presenting evidence. Now, class, during trial, when does the prosecution starts presenting its evidence? After arraignment and pre-trial. Diba? After arraignment and pre-trial, that is when the prosecution can present or can commence presenting its evidence. Now, the private offended party can ask the court to reserve the filing of the civil action before the prosecution starts presenting evidence. Now, class, if the prosecution has started presenting evidence, meaning presenting witnesses, presenting documentary evidence, presenting object evidence, then the private offended party may no longer reserve the filing of the separate civil action. Okay, what are the effects of reserving the right to separate civil action? Number one, the prescriptive period of the civil action that was reserved shall be told. When you say told, class, the running of the prescriptive period will be interrupted. Ibig sabihin, because you have reserved your right to file a separate civil action, that means that the running of the prescriptive period will not continue to run, or will not continue to commence as against the private offended party. Now, instances when the reservation to file a separate civil action is not allowed. Now, class, not all criminal cases will allow a reservation of the separate civil action. No, there are separate offenses or crimes where the rules of court will not allow the private offended party to file a separate civil action. What are those? Number one, criminal action for violation of BP 22 or bouncing checks law. Now, class, if you have filed a complaint affidavit for violation of BP 22, then the rules of court does not allow or do not allow you to what? Reserve the separate or reserve the filing of the separate civil action. Once you file your complaint affidavit for BP 22, then the civil liability or the civil action will be deemed as impliedly instituted with your criminal complaint. No? Ano ba ang tinatawag na civil action or civil liability in BP 22? Well, the amount of the check that bounced. No, that will consist of the civil liability. Okay. So in a criminal action for BP 22, the rules of court do not allow the reservation to file a separate civil action. Now, second, a claim arising from an offense which is cognizable by the Sandigan Bayan. Now, class, Sandigan Bayan is a special court. It is a special court because its jurisdiction consists of what? Graft, Anti-Graft and Corrupt Practices Act, or the offenses committed by public officers with salary grade 27 or higher, or the crime of plunder, as long as these offenses are committed by a public officer or employee with salary grade 27 or higher, Sandigan Bayan will have exclusive original jurisdiction over that case. So a claim arising from an offense which is within the jurisdiction of the Sandigan Bayan, then the private offended party also have no right to file or make a reservation to file a separate civil action. Okay. And then the third instance where the reservation is not allowed is in tax cases. So if you have implied a criminal action for tax evasion, for example, which is a crime under the National Internal Revenue Code, then the private offended party or the government may not reserve the right to file a separate civil action, meaning to say that the government will seek the payment of taxes in the same case as that of the criminal case. That is what you mean by the prohibition to reserve the right to file a civil action. Okay. Now, what is the effect of reservation of the right to file or the right to separate or to file a separate civil action? Only the civil liability arising from the crime charge or cause of action arising from delict as a felony is now deemed instituted with the criminal action. Okay. Now, when can a civil action may proceed independently of the criminal action? In other words, class, under these items, the civil action arising from the crime or the civil action arising from a different source of obligation will not be deemed or impliedly instituted with the criminal action. Kasi class, if you will study the law on obligation and contracts under Article 1157, there are 5 sources of obligation: law, contract, quasi-contract, delict, quasi-delict, or acts omission punished by law. Now, class, there are 5 sources of obligation, and crime or delict is only one of the sources of obligation. Now, class, there are other obligations which may proceed independently of the civil action. Kasi dalawang klase ang civil action class or civil liability. A civil liability may arise from a crime or it may arise out of other sources of obligation. Say, for example, contract, quasi-contract. No? These are other sources. Or for law, from civil law. These are other sources of obligation. Now, when you file a criminal complaint, this civil liability arising from other sources of obligation is not deemed impliedly instituted with a criminal action. Now, you may ask me, class, ano yung impliedly instituted with the criminal action? Well, that civil liability is that which arises from crime. If the civil liability arises from crime or from the delict, then that is the civil liability which is mentioned under the rules to have been impliedly instituted with the criminal action. I will repeat. If the source of obligation is, for example, law, civil law, contract, or quasi-contract, these civil liabilities are not deemed impliedly instituted with the criminal complaint. What is impliedly instituted in the criminal complaint is only civil liability arising from the crime. Okay. So, when can a civil action may proceed independently of the criminal action? Okay? Instances when civil actions may proceed ibig sabihin, class, kahit nag-file ka lang ng criminal complaint, pwede ka pa rin mag-file ng civil action. No, you cannot consider the civil liability as deemed to have been impliedly instituted with the criminal complaint. Kahit mag-file ka ng criminal case, pwede ka pa rin mag-file ng civil case. So what are those instances? Number 1, civil action arising from breach of contract and independent civil actions or those based on Articles 32, 33, 34, and Article 27 or 2176 of the New Civil Code or quasi-delict. Now, we will discuss them one by one, class. The first exception or the first instance when a civil action may proceed independently of the criminal action is when the civil liability arises from breach of contract. Kasi class, if the civil liability arising from breach of contract no is in instances when a contract is breached, then you can seek for damages and the source of liability is not the crime or delict but the violation of the contract. Remember, class, that contract is a separate source of obligation from a delict or a crime. Which is why if a contract is violated, you can file a civil action independently or separate from the criminal action. Okay. What are the so-called independent civil actions arising from Articles 32, 33, 34, and 2176 of the New Civil Code? We will go to them one by one. So Article 32. Any public officer or employee or any private individual who directly or indirectly obstructs, defeats, violates, or any other or in any manner impedes or impairs any of the following rights and liberties of another person shall be liable to the latter for damages. For example, violation of freedom of religion, freedom of speech. In other words, class, the civil and political rights enshrined under the Constitution. So if any public officer or employee or any private individual will violate the civil and political rights of every citizen as enshrined in the Constitution, then the civil action may proceed independently of the criminal action. Okay? That is Article 32. What about Article 33 of the Civil Code? In cases of defamation, fraud, physical injuries, a civil action for damages entirely separate and distinct from the criminal action may be brought by the injured party. Such civil action shall proceed independently of the prosecution and shall require only a preponderance of evidence. So under Article 33, class, in cases of defamation, fraud, and physical injuries, you can file a civil action independently of the criminal action. Ha, tandaan nyo, class, defamation, fraud, and physical injuries. Okay, so that's Article 33. How about Article 34? When a member of a city or municipal police force refuses or fails to render aid or protection to any person in case of danger to life or property, such peace officer shall be primarily liable for damages, and the city or municipality shall be subsidiarily responsible therefore. Okay, so that is Article 34. In case that a city or municipal police force refuses or fails to render aid or protection. Now, let us go to Article 2176 or quasi-delict. Okay. Quasi-delict. Whoever by act or omission causes damage to another, there being fault or negligence, is obliged to pay the damage done. Such fault or negligence, if there is no pre-existing contractual relation between the parties, is called quasi-delict and is governed by the provisions of this chapter. So class, under these exceptions, no, what we call independent civil action based on Articles 32, 33, 34, and 2176 of the New Civil Code, then the civil action may proceed independently of the criminal action. That means, class, that even if you have already filed a criminal action, you can file a separate civil action independently and separately from the criminal case. Okay? Under Article 32, let us review. You have their violation of the civil and political rights of the citizens under Article 33 in cases of defamation, fraud, or physical injuries under Article 34 when a municipal or city police force refuses or fails to render aid or protection to any person in case of danger to life or property. And then under Article 2176 of the Civil Code in cases of quasi-delict. So these are the exceptions to the general rule. These are the instances when the civil actions may proceed independently of the criminal action. Now, the failure to reserve the right to file the enumerated actions does not amount to a waiver to institute a separate civil action. Okay. Now, class, if a criminal action is filed and then thereafter a civil action is filed, this can be consolidated if they arises from the same offense. Now, the consolidation by the court can be done before the judgment on the merit is rendered in the civil action. Now, it can be upon motion of the offended party be consolidated with the criminal action in the court trying the criminal action. Okay. Now, when a separate civil action is suspended. Okay. As a general rule, class, if a civil action is instituted before the criminal action and the criminal action is subsequently commenced, the pending civil action in whatever stage it may be found shall be suspended until final judgment of the criminal action has been rendered. Okay? Now, class, we have what we call a primacy of criminal cases. No, primacy of criminal cases over civil cases. Now, if a civil action is filed in court before a criminal action, then the criminal action is deemed as suspended, or the separate civil action is suspended. So these are the exceptions, except in cases of independent civil action, as we have discussed. And then in case of a prejudicial question, later we will discuss the elements of prejudicial question. And number 3, when the civil action is not one intended to enforce the civil liability arising from the offense. Okay. Now, as a general rule, class, if the penal action or the penal liability is extinguished, then it will also extinguish the civil action. If there is no crime, then there can be no civil liability. But there are exceptions, class. Number 1, when there is a finding in a final judgment in the criminal action that the act or omission from which the civil liability might arise did not exist. Number 2, if the acquittal is based on the ground that he was not the author of the crime. Or number 3, if the acquittal is based on reasonable doubt on the guilt of the accused. The civil liability of the accused arising from the crime may be proven by preponderance of evidence. Now, class, if the accused is acquitted in the criminal case, then there can be no civil liability. In other words, class, pag nanalo ang akusado sa isang kaso, wala na siyang civil liability. Wala siyang babayarang danyos arising from the crime. But that is only the general rule. There are exceptions, no? Under the exceptions, the accused, despite acquittal, will be held liable for civil liability. Number 1, when there is a finding in a final judgment in the criminal action that the act or omission from which the civil liability might arise did not exist. Number 2, if the acquittal is based on the ground that he was not the author of the crime. Okay. Now, under these exceptions, class, then the accused will no longer have a civil liability. Okay? On the other hand, class, if the acquittal of the accused is only based on reasonable doubt, if the guilt of the accused has not been proven beyond reasonable doubt, then the accused will remain to be liable for the civil liability. Okay. What are the instances where the acquittal of the accused does not bar the continuation of the civil case? 1, if the acquittal is based on reasonable doubt. 2, the decision contains a declaration that the liability of the accused is not criminal but only civil in nature. And number 3, the civil liability is not derived from or based on criminal act of which the accused is acquitted. In other words, the liability is not from the crime or delict, but from a different source of obligation. Now, class, what happens if the accused dies? No? Pending trial of the case. What happens? What are the effects of death of the accused or convict on civil actions? If the accused dies after arraignment and during the pendency of the criminal action, as a general rule, the civil liability of the accused based on the crime is likewise extinguished. No, the civil liability of the accused based on the crime is extinguished. Kasi class, pag namatay ang akusado after arraignment and during the pendency of the trial, the prosecution may no longer prove the guilt of the accused. And therefore, the civil liability arising from the crime is extinguished by the death of the accused, except upon in cases of independent civil action under Article 32, 33, 34, 2176 of the new Civil Code. Okay. Now, if the accused dies before arraignment, then the offended party may file a civil action against the estate of the deceased. Now, if the accused dies pending appeal, then civil liability arising from the crime is extinguished, but civil liability predicated from other sources survive. For example, civil liability arising from law, contract, quasi-contract, and quasi-delict. Now, let us go to prejudicial question. Okay, what is a prejudicial question? Take note, class. This has been the subject matter of several questions in the board exam. Okay, prejudicial question. What is a prejudicial question? It is an issue which involves in a civil action which is similar or intimately related to the issue raised in a criminal action, the resolution of which determines whether or not the criminal action may proceed. Now, the prejudicial question may be raised during preliminary investigation of the offense or in court before the prosecution rests its case. Now, ano ba yung tinatawag na prejudicial question? Class, yung prejudicial question, it will involve two complaints or two actions, two court actions. Number 1, civil action. Number 2, criminal action. Dalawa ang isinampa sa husgado. At yung civil action class has an issue which is similar or intimately related to the issue in the criminal action. And that the resolution in the civil case determines whether or not the criminal action may proceed. Now, what are the elements of prejudicial question, class? Memorize these three elements of prejudicial question. Number 1, the civil action must be instituted prior to the criminal action. So, class, ang mauuna dapat na i-file civil action. After the filing of the civil action, if-file ang criminal action. Hindi pwedeng magkabaliktad. Hindi pwedeng mauna ang criminal action and then civil action. Kailangan mauna ang civil action. Okay? The civil action must be instituted prior to the criminal action. That is the first requisite. Now, the second requisite is that the civil action involves an issue similar or intimately related to the issue raised in the subsequent criminal action. And that the resolution of such issue determines whether or not the criminal action may proceed. These are the elements of prejudicial question. Class, memorize the elements of prejudicial question. Number one, the civil action must be instituted prior to the criminal action. The civil action involves similar issue or intimately related issue as raised in the subsequent criminal action. And number three, that issue in the civil action will determine whether or not the criminal action may proceed. No? These are the elements of a prejudicial question. In other words, class, you cannot determine whether or not the accused is guilty of the crime charge unless and until the civil action is terminated first. Kaya nga tinatawag dyan, prejudicial question. You cannot proceed with the criminal case unless and until the issue in the civil case is determined first with finality by the court. Ha? Tandaan niyo ang class. Okay. Bibigyan ko kayo ng example. Okay, I do not have it with the slide, but I will give you an example. Okay. Okay, class. In cases of prosecution for example, the falsification of a deed of sale. Yan, falsification of a deed of sale. Now, for example, class, may binibentang lupa, tapos nagpanggap yung offender na siyang may-ari ng lupa. Okay? And then, pinalabas niya na may deed of sale or may title na nakaregister sa pangalan niya. Kaya siya ang pipirma sa deed of sale. Okay? Ibebenta niya kunwari. Now, it turned out that the seller is not the registered owner of the property and that the title that he presented is spurious or not a genuine title. Na ano nangyari? Merong falsifikasyon ng titulo. Or kung hindi titulo, pwede nagpresent siya ng deed of sale and the deed of sale is likewise spurious. Okay. Now, what are the actions that you can file in court? Number one, you can file an action to declare the deed of sale as null and void because it is absolutely fictitious. Okay? Meaning it is falsified. And number two, you can also file a complaint, a criminal complaint for a falsification of the deed of sale. No, dalawa ang pwede mong i-file. Okay, now, pag nag-file ka ng civil case to annul the deed of sale because it was falsified, you will allege that the signature of the purported owner was forged or is fictitious. And then later on, you filed a criminal complaint for falsification of a commercial document. Then, the civil action is a prejudicial question. Anong ibig sabihin nun, class? When you say prejudicial question, the civil action asking the court to declare as null and void the deed of sale involves an issue which is similar or intimately related to the issue raised in the criminal action. In other words, class, in layman's term, bago mo malaman kung falsipikado ang pirma niya doon sa deed of sale, patunayan mo muna na falsipikado yung pirma niya, na hindi niya yun pirma, na hindi yun pirma ng registered owner, ng true owner of the property. Now, since the civil case involves what? An issue which is similar or intimately related to the issue raised in the criminal action, then the criminal action is suspended. Ititigil ang proceedings ng criminal action. Okay? Kailangan matapos muna yung civil action. Why? Because the civil action involves an issue similar or intimately related to the issue raised in the subsequent criminal action. Yan ang ibig sabihin ng prejudicial question. Okay? Okay. So that's it for Rule 111 or 111. No, prosecution of civil action. And then next meeting, we will discuss about preliminary investigation under Rule 112. Okay? Thank you for listening and see you next meeting. Thank you.